Joining me now, Director of Investigations at Judicial Watch, Chris Farrell. Chris, it's always a pleasure to see you and talk to you. Obviously, big news out of New York with the 45th president scheduled for a deposition. He decided to invoke his Fifth Amendment rights and go that direction in the deposition. Now, can you explain your thoughts on the decision overall? Would you have advised the president to go down that road?
This is a civil matter, first of all, and this is a matter brought about or brought by the Attorney General of New York, Letitia James, who's a person who has advocated openly about her desire to destroy Trump. When faced with a prosecutor who has taken such an extraordinarily aggressive position, one that arguably could result in some sort of sanction or bar complaint against her because it's so excessive. It's not unreasonable for the former president to say, look, I'm not going to cooperate at all with whatever it is that you're trying to do. If this is some sort of legal fishing expedition where you're going to ask 101 questions and just, see where it goes, you don't really have any charge or claim. You just want to get me under oath and sit me down and see how many times you can ask, a certain number of questions. Well, then, I'm not going to participate. I'm not going to actively cooperate with your fishing expedition.
Now, Chris, can you explain what the risks would have been had he decided to testify in this deposition? What type of risk would he be assuming when he, again, as you just discussed, a very politically motivated and charged prosecutor looking for reasons to take him down? What type of risk would he be assuming?
Right. Okay. So in the worst case scenario, I will give you an example. Before my 23 years at Judicial Watch, I was a U.S. Army counterintelligence officer, a special agent of Army counterintelligence. And I can tell you that if I sit you down and I interview you under oath for 2 hours, if I want to, I will be able to find some instance where you purportedly or allegedly would have engaged in some sort of, not necessarily perjury, but a contradictory statement. So I ask you a question one way and you answer. I ask you essentially the same question a different way and you answer a little bit differently. In one instance, you use the expression of, and another time you say from. And I point at that inconsistency in the statements and I say, aha, you see, you're being misleading. You're attempting to deceive me. You've made a false and misleading statement to a federal law enforcement officer. I can now charge you under 18 U.S. Code Section 1001, false official statement. See, people don't realize that when they're under oath and they're being questioned like that, very minor discrepancies in how they're being questioned opens the door to legal jeopardy. And an 18 U.S.C. 1001 false official statement claim is super easy. It's low-hanging fruit. And in theory, somebody being subjected to an hours-long deposition like that would open themselves up to that kind of legal exposure.
Director of Investigations at Judicial Watch, Chris Farrell, it is always a pleasure, sir. Thank you so much.
Thank you very much.